A public defender believes St. Lucie County Sheriff Keith Pearson lied under oath. It happened years ago, but it could impact criminal cases today. It's a story you'll see only on WPTV tonight. Our Megan McRoberts digging through court documents on this to understand how he is accused of misleading attorneys.
It's going to take months, if not years, to really get to the bottom of this.
Public Defender Diamond Liddy and her staff are pouring through this stack of documents.
Look at all this stuff. Got lots and lots of material that is Brady material.
Brady material, simply put, is information the state has to give up that could help the defense challenge the state's evidence or witnesses like law enforcement to help the defense's case.
So we can properly represent someone.
Here it's about Keith Pearson and a Lieutenant Rob Pettit's role in a traffic stop turned drug trafficking arrest in 2016. The records show Pettit pulled over Clyde Dennis Crouch after he said Crouch made an illegal U-turn and wasn't wearing a seatbelt. Sergeant Keith Pearson at the time had a drug-sniffing canine and happened to get to the traffic stop within minutes, finding drugs in the car leading to that drug arrest. But attorneys for Crouch questioned how Pearson got there so quickly and what both men knew about the car before Pettit pulled it over. I poured through these transcripts that show Pettit told Crouch's attorney it was a cold traffic stop. He didn't have info about the stop or the contraband inside it ahead of time. And he denied having any cell phone communication with other officers about the stop before making it. Pearson in transcripts claimed he got to the scene so quickly because he heard Pettit make the traffic stop over the radio and happened to be right around the corner. When asked if he talked with Pettit on the phone before the stop, he said no. But the state attorney says the DEA came forward with contradictory information, prompting Crouch's attorney to question Pearson and Pettit again.
You would say it's pretty unusual to have to redepose a witness?
Sure.
Okay.
Absolutely.
Transcripts show their stories changed. Pettit conceding this was no cold traffic stop, but that the DEA told Pettit Crouch's car was coming into the county. And the goal was to go out, locate the vehicle, and search it if you can. He told the attorney what he previously said was inaccurate. Pearson also admitted he did omit information, clarifying he didn't just happen to be in the area. And this time, when asked about talking with Pettit on the phone beforehand, he responded, well, yes. So why the inconsistencies in their stories? We reached out to Pearson asking for a statement. He's not yet responded. But in transcripts, Pearson said he did not want to disclose the active DEA investigation to protect the DEA's case. Liddy says that's no excuse.
You can go off the record and discuss things. The ramifications are pretty extraordinary.
Their depositions were so harmful to the state's case, the state attorney confirmed to me that instead of pursuing a 30-year sentence for Crouch, the state instead only asked for a 4-year sentence. The state attorney also requested an investigation into Pearson and Pettit, but FDLE declined to pursue it, saying there was, quote, just nothing there. Liddy says she doesn't need a perjury charge, though, to question their credibility and role in her clients' cases.
You have a duty to do the right thing and to be honorable and to tell the truth.
Megan McRoberts, WPTV News.